You're listening to Portfolio, the property law podcast from Davis Blank Furness.
Hello and welcome to Commercial Property Insights, the podcast from Davis Blank Furness, where we unpack the legal complexities of commercial property in a way that's practical, accessible, and genuinely useful for you, our listeners. I'm Rosie, Korcz, a partner in the commercial property team. I focus on transactional work, helping businesses, SMEs, and high net worth individuals navigate property acquisitions, disposals, and leases.
And I'm Seán, Hackett, head of the property litigation department here at Davis Blank Furness. And whilst Rosie's dealing with the deals, I'm often picking up the pieces when things go wrong. Disputes over lease terms, forfeiture proceedings, dilapidations claims, that sort of thing. It's a different perspective, but both sides of the coin are crucial to understanding commercial property properly. And today, we're tackling what can be one of the most contentious areas of commercial leasing: repair obligations. And given these fall on the tenant's shoulders, today's podcast will be more tenant leaning, but landlords and their advisors will benefit from today by getting an insight into what tenants ought to be doing.
Absolutely. And we'll also be looking at schedules of condition, which can be an absolute lifesaver for tenants, and interim schedules of dilapidations for those buying businesses that operate from leasehold premises. These are issues that crop up time and again, both at negotiation stages, when I'm acting for clients taking on new premises, and inevitably at the end of the lease, when things can get expensive.
Indeed, and I've seen disputes over repair obligations costing businesses tens, sometimes hundreds of thousands of pounds. The fascinating thing is that many of these disputes could have been avoided with better negotiations at the outset. So hopefully our listeners today will pick up some practical points that'll help them avoid the problems that we'll discuss.
Now, before we dive into the detail, let me set the scene for our listeners. When a tenant is taking on commercial premises, whether it's an office, a warehouse, a retail unit, or an industrial premises, one of the most significant ongoing obligations the tenant will have is keeping the property in repair. Repair in a commercial lease is not as simple as tenants might think. Understanding repair is about understanding exactly what repair can mean in terms of works, and also understanding the standard of repair that the tenant is committing to, and what that commitment might cost the tenant during the course of a tenant's occupation, and crucially, when they come to leave.
Yeah, and people can be forgiven for reading the words repair and condition in a clause and think, yeah, I know what that means, fix it if it's broken. But I can assure you there's more to it than that. And the raft of case law over the last 100 plus years evidence that the court's interpretation of repair and separately condition means a good deal more than just fixing it. A useful definition of repair, which distinguishes it from renewal, is contained in the case of Korcz versus Wakely and Wheeler. It's a 1911 case, and it says this: repair is restoration by renewal or replacement of subsidiary parts of a whole. Renewal, as distinguished from repair, is reconstruction of the entirety, meaning by the entirety, not necessarily the whole, but substantially the whole.
Hold up. So in certain circumstances, in order to repair things, you might have to renew or replace parts of the thing in disrepair.
Correct. And the obligation to renew, which is different from the obligation to repair, involves reconstructing substantially all of the thing in disrepair.
So let's just pause here and get it right. Repair can oblige you to renew parts of the thing in issue, but not a substantial part of the thing in issue. But if you have to reconstruct substantially all of the thing in issue, that's not a repair. That's a replacement.
Yes, and you can see why there are arguments with the tenant saying that the works to fix the issue amounts to replacement, and the landlord saying, no, it doesn't, those are works of repair.
Yeah, I can see that.
Now, then you add the word condition to the obligation. So the obligation is to keep the premises in good repair and condition. And condition gives an additional layer of obligation to the meaning of the word repair. It effectively requires the tenant to carry out works if something is not in good condition. even if that condition has not, as of yet, led to a state of disrepair. And we haven't even mentioned the effect that the word keep has on those obligations. The fact that the tenant is obliged by the lease to keep premises in repair, well, the courts have said that if the premises are out of repair, a tenant must first put the premises into repair before they can keep it in repair. So if the premises are not in repair at the point the tenant enters into the lease and the tenant has agreed to keep the premises in repair, then they will be obliged to undertake repair works on day one of the lease. Now that sounds harsh, but that's what keep in repair means.
It is very common, and it is very harsh indeed.
And then we have the added complication that if there is a defect in the premises, for example, the roof design was poor and water was making its way into the property causing damage, ordinarily the tenant is not obliged to remedy that inherent defect because those works are not repair works.
I am sensing a however here.
Yes, indeed. However, if the defect is resulting in damage being caused, so say the water is causing the plaster to fall off a wall, the tenant is responsible for repairing the plaster.
Surely the plaster will continue to get damaged each time the defective roof lets rain in.
Indeed, and if the only way to prevent that disrepair reoccurring time and again is to deal with the defect, then guess what? The repair will require the defect to also be addressed.
So, those 5 words, keep in repair and condition, if not qualified, can mean so much more than they may first appear.
Exactly. And now that we have laid the basic foundations in relation to repair, let's begin by looking at FRI leases versus IRI leases. And if I might, can I ask you to keep to the basics, Rosie? What's the difference between a full repairing and insuring lease, which everybody calls an FRI lease, and an internal repairing and insuring lease, or an IRI lease?
Right. So in simple terms, an FRI lease places the burden of repair on the tenant. We're talking about everything: the structure, the exterior, the interior, the roof, the foundations, the windows, the lot. The tenant is also responsible for insuring the building, although in practice, the landlord usually arranges the insurance and then recovers the premium from the tenant through the service charge or as an additional insurance rent.
And that's typically what you see with single-let properties, a standalone building occupied by one tenant on a long lease. Is that correct?
Yeah, exactly. If you're a business taking the whole of a building on, say, a 10 or 15-year lease, the landlord will generally want an FRI lease. From the landlord's perspective, it's a completely hands-off investment. The rent comes in, the tenant deals with everything, and at the end of the term, the building should be returned in the same condition it was at the start.
And I imagine for tenants, that can be quite daunting, particularly if the building is older or is in poor condition to begin with.
Absolutely. And that's where schedules of condition become so important. And we'll discuss them in detail shortly. But yes, if you're a tenant being asked to take on full repairing obligations for a building that's already showing its age, you need to think very carefully about what you're taking on. I always advise clients to get a building survey done before committing to an FRI lease, particularly on older properties. Those surveys are not just in respect of the fabric of the building, but also look at the plant and machinery. Yeah,
the plant and machinery is a really important one. So now, what about IRI leases? How do they differ?
Okay, with an IRI lease, which is often referred to as an internal-only lease, the tenant is only responsible for the interior of the premises. The landlord retains responsibility for the structure, the exterior, the roof, and the common parts. This is a typical arrangement in multi-let buildings, so your office blocks, shopping centres, business parks, etc.
So if you're occupying, say, a unit in a business park or an office suite in a larger building, you'd expect an IRI lease.
Yeah, in most cases. The tenant maintains their own space and the landlord maintains everything else. The landlord will then recover the cost through a service charge, which the tenant has to contribute to. Now, the devil is very much in the detail here, because what constitutes the interior is not always as straightforward as you may think. Think about windows. For instance, is the glass part of the interior or the exterior? What about your window frames? Or internal structural walls? Or the floor slab? Or which particular part of the ceiling? These are all things that need to be clearly defined in the lease. The surveyor or agent who is dealing with the heads of terms in lease negotiations should be identifying all of this to allow us transactional solicitors to define them correctly within the lease itself.
Quite right. That's a brilliant point. And I have seen disputes arising because the lease was ambiguous about where the tenant's repairing obligations began and the landlord's ended. And from a tenant's perspective, is an IRI lease generally more preferable to the FRI lease?
To be honest, it depends on the circumstances. An IRI lease certainly limits the tenant's exposure in one sense. You're not on the hook for replacing the roof or repairing structural defects. But you are exposed to whatever the landlord decides to spend on maintaining the building, which you will still pay for through the service charge. If you've got a landlord who's very proactive about maintenance, your service charge could be substantial. Conversely, if you've got a landlord who doesn't maintain the building properly, you could end up with premises that's difficult to occupy or trade from.
Whereas with the FRI lease, you've got complete control over the maintenance decisions. Is that right?
Yeah, precisely. You decide when to fix things, who to use, and how much to spend. For some businesses, particularly those that are property savvy or have in-house facilities management, that can actually be preferable. The key for tenants is understanding what they are taking on and being comfortable with it. This is where they really need to engage their surveyors and agents.
Okay, so we now know the difference between the FRI and the IRI lease, both of which require the tenant to undertake repairs. Let's talk about the actual standard of repair that tenants are required to meet. This is where I see a lot of confusion, and it's often at the heart of dilapidations dispute. Rosie, what does repair actually mean in the legal terms in that sense?
This is where it gets a bit technical, but it is really important. In law, there's, as you touched upon, a distinction between repair, renewal, replacement, and improvement. Repair means making good damage or deterioration to restore the property to the condition it was in previously. It does not mean making it better than it was. That would be an improvement. And it doesn't mean wholesale replacement unless that's the only way to effect proper repair.
So if we take a practical example, let's say the roof is leaking. Now, it's not owing to a defect, but say it's a fissure in the roof panels. Repair would mean fixing the leak, but not necessarily replacing the entire roof.
Exactly. Unless the roof has deteriorated to such an extent that patching it up is no longer a viable repair, and replacement is the only sensible option. There's quite a lot of case law on this. The courts will look at whether the work goes beyond repair into the realms of renewal or improvement.
And then there's this phrase that appears in some leases, fair wear and tear accepted. What does that actually mean? Because I think a lot of tenants assume it lets them off the hook for more than it actually does.
Yeah, you're absolutely right. And this is a source of real confusion. Fair wear and tear accepted means that the tenant isn't responsible for deterioration that occurs through the normal, reasonable use of the property over time. So if a carpet wears thin from people walking on it, that's fair wear and tear. If paintwork gradually fades, that's fair wear and tear.
But here's the crucial point. The tenant is still responsible for preventing any consequential damage that flows from fair wear and tear, aren't they?
Exactly. So let's take an example. If a roof tile comes loose through weathering over time, that might be fair wear and tear. But if the tenant notices the loose tile, does nothing about it, water gets in, and you end up with rot in the roof timbers and damage to the ceiling below, the tenant is liable for that consequential damage. Fair wear and tear does not excuse you from taking action to prevent further deterioration. That's why regular maintenance and prompt attention to defects is critical. From a tenant's perspective, it is far cheaper to fix a loose tile than to deal with structural timber decay and ceiling damage. Absolutely.
And it's also why having a good relationship with your landlord and clear reporting processes can be invaluable. If you have an internal-only lease and you notice something that the landlord's responsible to fix, report it immediately and keep a record that you've done it. That way, if consequential damage occurs, you can demonstrate that it wasn't down to your failure to act.
And it's worth saying that in an FRI lease, tenants should be conducting regular inspections and maintenance. Don't wait until problems become serious. Preventative maintenance is nearly always cheaper than emergency repairs.
Right, so a quick recap. We have learned that repair is not the same as renewal or replacement, albeit, in some instances, depending on the extent of the disrepair, in order for the tenant to repair something, they may be required to renew or replace something, with the result that there is an improvement. Now, you mentioned a short while ago needing to engage surveyors before the lease is entered into, particularly for aged buildings. Now, this takes me to the topic of schedules of condition, because this is one of the most important protective, proactive measures, I think, that a tenant can negotiate when taking on a lease, particularly an FRI lease.
Absolutely. A schedule of condition is essentially a detailed photographic and written record of the state of the property at the start of the lease. It's usually prepared by a surveyor and then appended to the lease as a schedule. The repairing covenant in the lease is then amended to say that the tenant must keep the property in no worse condition than as evidenced in the schedule of condition. It's important that the surveyor inspects the plant and machinery and the service media too. It's not just the walls, the floors and the roof. If you need to get M&E experts in to assess these items, then that's just what needs to be done. If it materialises that those items are at the end of their life expectancy and the tenant still wants to proceed with the lease, then specific repair, renewal and replacement exclusions can be included in the lease at that stage.
Yeah, and they really ought to be. That's a really important point. M&E, plant and equipment, they're often overlooked for the surveys doing the schedule of condition. So rather than having to keep the property in a good and substantial repair or whatever the lease might otherwise require, the tenant only has to keep it as good as it was when they took it on. And say some piece of plant, for example, a heating system's on its last legs, and to repair it would require replacement, the lease should make it clear that the heating system need not be replaced if it's beyond economic repair.
Precisely. This is absolutely crucial if you're taking on an older building or one that's already showing signs of wear and tear. Without a schedule of condition, you could find yourself liable at the end of the lease for putting right defects that were already there when you moved in.
Yeah, so coming back to schedule of condition, I would say from a litigation perspective, a good schedule of condition is worth its weight in gold when it comes to defending a dilapidations claim. If there's a comprehensive schedule showing the certain defects that already existed, it's very difficult for a landlord to pursue the tenant for those items.
The key word there is comprehensive. I sometimes see schedules of condition that are quite cursory, maybe just a few photos and some brief descriptions. Those aren't particularly helpful, but it occasionally happens that our instructions are, don't worry about that, just stick it to the lease. A proper schedule should be room by room, item by item, with extensive photographs and detailed descriptions of the condition of all elements, and ideally with measurements and technical specifications.
And presumably that'll come at a cost.
It does. But compare that to the potential dilapidations liability at the end of the lease. It's usually money very well spent.
I couldn't agree more. I've seen dilapidation claims running into six figures where £1,000 spent on a schedule of condition at the outset would have provided a defence to large parts of the claim.
Now, it's worth noting that landlords don't always agree to schedules of condition. If you're a tenant and you request one, the landlord may well push back, particularly if it's a new or recently refurbished building. They might argue that they don't want to limit your repairing obligations because the building is already in excellent condition.
And how would you deal with that in the negotiations, Rosie?
So if a landlord's not keen on the idea of a schedule of condition, or if there are items identified at the start of lease that are already well beyond economic repair, a schedule of landlord's works may be a good option. This can be effective where there is a certain item or class of items that can be rectified by the landlord in advance of the lease being granted. Common example here is works that may be required to bring the property up to a higher energy performance rating. So in practice, you need an agreement for lease to make this work. You can see episode 1 for more wisdom from us on agreements for lease. Within your agreement for lease, the landlord will set out the works they intend to carry out. Once the works are complete, the tenant will take the lease. This brings the landlord the comfort that the investment they are making in their property will be worthwhile, as they have a tenant waiting dutifully to step in. It also works for the tenant, as they will have those newly completed works to a good standard and hopefully will not need to worry about the repair of those items for some time. Ultimately, whether or not you get the landlord to carry out the works or agree to append a schedule of condition, all depends on the bargaining position of the parties. If it's a landlord's market and there are other potential tenants queuing up, you may have to accept full repairing obligations without a schedule of condition. But if you've got more negotiating leverage, push for it. Sometimes it's about explaining the commercial rationale to the landlord. You're not trying to avoid proper maintenance, you just want clarity on your starting position.
Yes, and landlords should understand that it's actually in their interest too in some ways. A clear schedule of condition prevents disputes later on, which can come with very hefty legal costs. And with a schedule of condition, both parties know exactly where they stand.
That's a very good point. Another compromise position I sometimes negotiate is a schedule of condition that only covers specific elements of the property. So perhaps the structure and exterior are excluded from the schedule, but we include the interior fixtures and finishes. That way, the tenant isn't taking on responsibility for putting right existing defects in decorative conditions or worn-out fittings, but the landlord still has the comfort of full structural repairing obligations.
So schedule of conditions are prepared typically before the lease is entered into. Let's turn to a related but slightly different topic. Interim Schedule of Dilapidations. This is particularly relevant, Rosie, for clients who are buying a business that operates from leasehold premises, isn't it?
Yeah, this is a scenario we see all the time. A client is buying a business, maybe a restaurant, a dental practice, lots of nurseries these days, and the business trades from premises that the seller has leased rather than owned. The buyer, instead of taking on a freehold property, which is generally less weighed down by obligations, is going to take an assignment of that lease as part of the purchase.
And the challenge is that the buyer is stepping into the seller's shoes in terms of all of the obligations under the lease, including any disrepair that's accrued during the seller's tenure. Isn't that right?
Exactly. So let's think of an example. A lease might have been granted 10 years ago and, shock horror, the seller may not have maintained the premises as well as they should have done. If the buyer simply takes an assignment without protection, they will find themselves liable to the landlord for all that disrepair when they eventually give up the lease at the end of the term.
So what's the solution then?
An interim schedule of dilapidations. This is a surveyor's report commissioned during the purchase process, which identifies all the disrepair and the breaches of repairing covenants at that point in time. It puts a cost on remedying those breaches and is effectively a snapshot of the dilapidations liability at the point of assignment. This can be absolutely vital.
Yeah, and that won't impact on the repair obligations in the lease. They remain unaltered. But what the interim schedule of dilapidations does is it feeds into the commercial negotiation between the buyer and the seller.
Precisely. Once you know that there's, say, £50,000 worth of disrepair, the buyer will have a few options for negotiating depending on their bargaining power. Ideally, the buyer will look to negotiate a reduction in the purchase price to reflect that liability. Alternatively, they might require the seller to carry out the works before completion, or there might be a retention, so they hold the money back from the purchase price. The money would be held by the buyer's solicitor and will be used specifically to fund the works post-completion.
Yeah, and this sounds like it needs to be factored in early in the transaction timeline.
Yes, please. The interim schedule of dilapidations needs to be commissioned as soon as heads of terms are agreed. Trying to squeeze it into the last week before completion will cause everybody no end of stress. It might help if I lay out the timeline of what actually needs to happen. So, your surveyor needs to access the property to inspect it, which requires the seller's cooperation. The report takes time to prepare, and then there's negotiation based on the findings. If you leave this until the last minute, you'll either end up in a rush or you'll complete without the protection and discover the problems later. This is an unnecessary and potentially costly compromise.
I can hear from your voice that this is something that you've run into a few times, is it?
Yeah, absolutely.
So, and from my perspective, I've seen situations where a buyer hasn't obtained an interim schedule. They complete the purchase, and then a couple of years later, when they come to give up the lease or sell the business, the landlord serves a dilapidations claim, and they want to know what they can do. And if the agreement between the buyer and the seller does not address the issues of repair, then the buyer foots the bill for the repair costs.
And presumably any indemnity or warranty in the business sale agreement will have time limits and may be difficult to enforce years later.
Exactly, and sellers go out of business, they move abroad or become uncontactable. Even if you've got a good warranty, enforcing it can be challenging. In addition, in the absence of an interim schedule of dilapidations, it's actually difficult to prove which breaches existed at the point they took the assignment of the lease and which have arisen since. It's far better to identify the issues upfront and deal with them as part of the transaction.
Now, it's worth mentioning that there's often a landlord's perspective to consider here. In some cases, particularly if a lease is coming towards the end of its term, a landlord may insist on a schedule of dilapidations being prepared before they'll consent to an assignment. They want to know what state their property is in, and they may require either the outgoing tenant or the incoming tenant to address certain items before the assignment.
And that's entirely within the landlord's rights if the lease requires the landlord's consent to assign, which most leases do. And indeed, that may indeed be an express provision in the alienation clause itself.
Yeah, although the landlord can't unreasonably withhold consent, if there is a material disrepair, a landlord is generally acting reasonably if they require it to be addressed before they'll let the existing tenant off the hook by allowing the assignment.
Rosie, let's talk about some preventative strategies. What should tenants be doing during the term of a lease to minimise their eventual dilapidations liability?
First and foremost, it's the same old position. Understand your lease. I know that sounds obvious, but you'd be amazed how many tenants don't actually know what they're required to do under their repairing covenants. So dig out your lease, read the repairing clauses, and if you're not sure what they mean, give DBF a call and we'll give you some advice. Knowing your obligations is the first step to complying with them.
Yeah, I agree with that. And then from there, where do you go?
Regular inspections and maintenance. For an FRI lease, I'd recommend a formal inspection by a surveyor every 3 to 5 years, with an internal review annually. If you're required to redecorate every 3 or 5 years under the lease, make sure you actually do it and keep your receipts. If you have an internal-only lease, make sure you're reporting on defects that are the landlord's responsibility promptly and in writing. If the landlord is slow to act, chase them up. A friendly reminder won't do either party any harm. As we discussed earlier, you don't want to end up liable for consequential damage that arose from the landlord's failure to maintain their part of the building.
Another point I'd make is to consider having a surveyor review your repairing obligations at least a year or so before the lease is due to expire if you're planning to give it up. That gives you time to carry out any works needed in planning cost-effective way rather than rushing to do things at the last minute or facing a dilapidations claim after you've left.
Yeah, that's a really good point. I've got a bit of a call to action here, so wake up if you have dozed off. If you're planning on using a break option to terminate the lease early, knowing what your lease says becomes even more critical. Many of the more old-fashioned break clauses require you to have complied with your covenants within the lease, and this will include the repairing covenant. If you haven't, the break might be invalid, and you could be stuck with the lease for the remainder of the term when you had planned to move on to pastures new. This can be a really big issue for tenants. Let me paint you a picture. If you have a floor in an office block that it turns out is just too big for your business to manage, it happens. Luckily, you have a break coming up in 8 months' time. You serve your break notice and you plan to move on. You even take on obligations for a new, smaller property just down the road. The break date arrives, but the landlord advises that your attempt to break is invalid because you did not replace the carpets as the lease said you should have done. Now, you may think that I'm exaggerating, but it really can be that simple. In the Henderson case from 2014, a tenant had sought to exercise their break. On the break date, a single fence panel was rotten. The tenant chose to repair it with a sheet of tarpaulin rather than the wooden panelling they should have used. The landlord successfully argued that the repairing covenant had not been complied with. Thus, the tenant had to pay the landlord £70,000 in damages and also had to continue as the tenant under the lease for the rest of the term.
Quite incredible. That brings us neatly back to the importance of understanding your lease and planning ahead. These aren't things that you want to be discovering at the last minute at all.
Absolutely not. Commercial property is all about planning and understanding your obligations. Whether you're negotiating a new lease, taking an assignment, exercising your break, or coming towards the end of your term, getting proper advice early makes an enormous difference to the outcome.
So before we wrap up, Rosie, what final tips would you give to landlords, tenants, surveyors and agents who are negotiating and repair clauses that are to go into a new lease?
Well, first, don't treat the repairing covenant wording as standard. I see this sometimes. Clients focus all their energy on negotiating the rent, the term, maybe a break clause, but they gloss over their repairing obligations. Don't. The repairing covenant could end up costing you more over the term of the lease than the rent itself.
And presumably this links back to getting the survey done.
Yeah. Before the tenant commits to full repairing obligations, have a survey carried out. Understand what condition the property is in, inspect the plant and machinery and the service media, and that way the tenant will know what the property is likely to need over the term. If there are significant issues, an old roof, aging mechanical plant, structural concerns, factor that into your opening negotiations. Tenants might push for a schedule of condition or seek a contribution from the landlord towards capital expenditure or negotiate a different repairing obligation altogether.
Indeed. Well, I think we've covered a lot of ground today. The key takeaways for me would be to understand the difference between the FRI and the IRI leases and what tenants are taking on. Don't underestimate the importance of schedules of conditions. And if tenants are buying a business with a leasehold property, get an interim schedule of dilapidations and maintain good records throughout the term of the lease.
I'd echo all of that, but I'd add, get advice early. Whether you're taking on a new lease, inheriting one through business purchase, or approaching the end of your term, talk to a solicitor and a surveyor sooner rather than later. These issues are far easier and cheaper to deal with proactively rather than reactively.
Well, thank you for that comprehensive discussion, Rosie. Next time on Commercial Property Insights, we'll be looking at alienation, underletting and assignment, as well as AGAs. So we'll have plenty to discuss.
Indeed. Until next time, thanks for listening to Commercial Property Insights from Davis Blank Furness. If you've got questions on anything we've covered today, get in touch by visiting our website, www.dbf-law.co.uk. Take care.